Oh,
Well, good morning, everyone. Thank you so much for joining us today. My name is Carolyn Knowles, and I am the Interim Director of Development and Alumni Relations at the University of San Francisco School of Law. And you are joining our webinar on data privacy in the time of COVID-19 with adjunct faculty member Everett Monroe and alum Peter Micek. And Everett is also an alum of USF School of Law. Before I introduce our two speakers today, I wanted to cover just a couple of quick housekeeping things. All of the attendees, you are muted right now, but we would love for you to participate by asking questions using our Q&A feature. Everett and Peter will be chatting for about 30-40 minutes, and then they will open it up to questions using that Q&A feature. So please ask questions there, and they will get to as many as they possibly can. If you have any technical issues during this webcast, please email lawevents@usfca.edu, and we'll reply as quickly as we can. This webinar is also being recorded, and so we'll be emailing it to you afterwards as well. So with that, let me introduce our speakers today. Peter Micek, class of 2011, is General Counsel at Access Now. Over the last decade, he has been advocating for freedom of expression, privacy, and access to information online. In his role of General Counsel, he leads the legal arm of a global human rights organization with a particular focus on the telecom and tech sector and the defense of civic space online. He lectures on internet policy and governance at Columbia University's Graduate School of International and Public Affairs. As a student at USF, Peter defended independent journalists in freedom of information litigation at First Amendment Project and engaged in youth and ethnic media development at New American Media Pacific News Service. Everett Monroe is a grad of the class of 2014 and is an attorney at Zwilgen, where he advises a wide range of clients on state, federal, and international data privacy laws and regulations. He is an adjunct faculty member at USF School of Law and teaches information privacy law, delivering lectures about diverse data privacy legal frameworks and current developments. Welcome to both Peter and Everett. I'll let you take it from here.
All right, thank you, Caroline. So good afternoon or good morning, wherever you happen to be. Again, my name is Everett Monroe. I'm an adjunct professor here at the School of Law. And there was just a lot going on with privacy and particularly how it relates to public health and human rights and surveillance. And so we felt that this would be a timely topic for Peter and I to discuss with all of you. Again, I want to emphasize, if you have questions, put them, go ahead and post them. We'd love to hear them. And we're going to be moving kind of fast. We've got a few topics today. Our big one is going to be how different legal frameworks approach contact tracing technology. And then we're going to move into some more specifics, things that are a little bit more focused on the United States and its approach. And then with a little bit of legal ethics on the side, we're going to talk about, how the move from, all of our offices and our legal offices, and our moves to sheltering in place and staying at home are going to affect maybe some of our obligations of confidentiality and competence under the model rules or the rules of professional conduct for both New York and California. So, I sort of wanted to kick things off with a touch point, and then I'll have Peter chime in. And I was just reading an article on Reuters that was talking about how Apple and Google and data protection authorities in the European Union were not exactly seeing eye to eye on contact tracing apps and how they should be used and how they should be structured. And I get the impression that a lot of my friends and a lot of what has been going on in popular press has been to say that Germany and the European Union is somehow lessening their privacy standards, or that these tech companies are forcing their way in and enforcing an American point of view. And I think I wanted to start with just asking you, Peter, there's this sort of misconception that Americans or American law cares less about privacy than European jurisprudence. And I wanted to see, just sort of start with your broad thoughts on that.
Thanks. Thanks, Everett, and thanks to USF for hosting this really timely conversation that I'm really glad to be a part of. So I've had the privilege of waking up early for calls with our Brussels office for the last 8 years or so at Access Now, and have really gotten an education through that weekly and sometimes daily conversation with them. And the approaches between the US and the EU are distinct in the how, but at their heart, they are rooted in the same basic principles. I know that because a lot of these principles were developed and passed through the US government even before European member states and ultimately the European Union took up these principles. But to take a step even further back, Americans absolutely prize our privacy rights. The Fourth Amendment to the US Constitution, it's not the first, right? So it's not maybe quite as important as free expression in the eyes of the founders, but the Fourth Amendment is still one of the strongest protections against law enforcement access in the world. It's one of the stronger restraints on law enforcement activity under government. So absolutely, Americans have a deep history. Often this love of privacy gets expressed a bit stronger vis-a-vis the government than commercial actors of the private sector. It's usually seen as a right to be left alone. But following, I would say, the mid-century, the reign of FBI Director Hoover, we see a passage of laws in the United States that really understood the information age was already here and definitely not going away, and tried to put into practice fair information privacy principles and through the Privacy Act of 1974 that, again, at their heart, really are similar to what we see the European Union pushing today. So these are basic principles. I have the right to understand who has access to my personal data that identifies me or through which I'm identifiable. I have the right to know who's collecting this data, to know how they're processing it, to object to certain types of processing, to access the data, to rectify any mistakes, ask for deletion where legal, and know who else has access to it, what kind of sharing is taking place. So these kind of purpose limitations, the purpose for which the data is collected and processed, objecting to who has access and how it's shared, the ability to participate really in control over your personal information is at the heart of US laws, and we're seeing really take root and find teeth in the European Union's approach.
And I also think that sometimes there is sort of a difference in where these different legal frameworks place their emphasis. So, particularly United States law seems to place a lot of their emphasis in terms of managing privacy on the principle of consent and participation. That, it's the first thing you want when you're doing anything. That's why we have all these privacy policies that say, by at some point glancing at this privacy policy, you have agreed to all of our terms. Don't worry about the big words. Well, Europe seems to take much more of an emphasis on purpose specification and data minimization. Does that sound like a fair characterization to you?
Yeah, I think that does sound fair. And I think you might be able to even broaden it to say that Europe takes a more sector-wide approach and doesn't, I would say, or tries not to burden the individual quite so much, right? To understand what they're being asked to consent to, right? We don't have time to read all the terms of service and use that are presented to us. And you really can, sell the farm in some of those terms in the US approach. Whereas, yeah, I think data minimization certainly is a principle that infuses the General Data Protection Regulation, and before it, Europe's Data Protection Directive of 1995. And minimization is something that my organization certainly promotes as an overarching value. Minimization means, collecting as little data as you need for the specific purpose for which it's being collected, right? What you're trying to achieve with this data should be, first of all, known beforehand, and be explained to the customer, or the client, or the data subject, who this data describes. I'm chuckling because I think a lot of the tendency of Silicon Valley companies is to collect it all first and then figure out what to do with it.
Yeah, I can definitely understand that. But and now I guess getting into the nitty-gritty of particularly public health, even under European Union law, United States law, really even international conventions, the right to privacy or the right to private life or Fourth Amendment protections are not an absolute. And it seems like this would be one of those circumstances where it is supposed to give way a little bit. It isn't a pandemic the reason why, we put in all of these little exceptions to all of these rules, and we try to find that right balance to protect public health. Isn't this one of the purposes that, laws, create an exception for?
Yes, on its face, and that is true, that these laws are not absolute. Very, very little of what we deal with, even in the human rights framework, is absolute. And they do have built-in exceptions. I think, I want to make a few things clear before getting to those exceptions. First of all, there are often clear exceptions for public health crises in both data protection and privacy laws. And it's a little nitpicky, but data protection is a different right than the right to privacy under the Charter of Fundamental Rights in the EU. And I think it can be helpful to think about those as overlapping but separate rights. But yeah, these do have exceptions for public health, for research, in the public interest. And these laws also provide a framework with safeguards around the increased ability to process data. So they do have exceptions, but then they also have a set of, usually processes that need to be followed to make use of these exceptions. Now, what I want to make clear is that we are not in an extra legal scenario. We're not in a never before seen situation. Actually, a lot of these rules and these laws, especially the International Human Rights Framework, came about after major crises, right? We can look at World War II and the development of the international system after that. So they totally understood that derogation at times would be necessary. And they can create a legal framework that's flexible enough to allow that time-bound, specific, above board and understood derogation in time of crisis. And so that's why, my organization is clear that it's not a matter of whether health data, really sensitive, individually identifiable health data, it's not a matter of whether it can be used in order to save lives in this crisis. It's a matter of how. And that opens the door to discussion of the application of these rights to the digital world.
And I will say that in the last few weeks for me, how has been a really interesting question, just because we have been seeing, at work, a lot of requests for, 50 state surveys of responses to COVID. And we're not really going to get into employment, workplace privacy and temperature screening and all of that today. But there have been, a lot of different approaches in countries and in general, Japan, China, Europe, the United States, and what they have said is permissible for protecting public health, what is just a little bit beyond the pale. And, and I guess a big question that a lot of the firms have been facing and a lot of my colleagues have been talking about is how we navigate this on a larger scale. What are the international touchstones that we can use if we're trying to manage this in 7 different countries and 14 different states? What do we do? Is there some sort of standard that we can point to that will help us navigate it?
Thanks. Yeah, that's a really timely question, and I don't think anyone has all the answers. I definitely do go back to the basic principles underlying the legal framework, and you want to look to those basic data protection principles of why are we collecting this data? Is it necessary for a specific purpose? In this case, the purpose would be, I suppose, finding those affected or potentially at risk, notifying them to keep themselves safe, and then informing the authorities who are mapping their response at a national level and international level. So yeah, it's purpose prong. It's limitations and access to the data. We're not going to be sharing this widely. And looking back at a previous example, the Ebola response in around 2014, 2015, access was a big problem. There were requests from all over the world for all the mobile location data and call detail records, in some hope that it might shed some light on how the virus is moving. But in fact, the utility of that information was really limited, and there weren't clear legal processes in place in order to extend access, under a rights-respecting, rule of law-based regime. So again, purpose limitations, necessity, and proportionality of what you're doing, of what's being collected. And, I wish I could show my screen, but a coworker just developed a nice graphic for this, showing the COVID tracking apps. And that's really the way that governments are moving this forward is, there's an app for that. And so they're rolling out these apps, and in some cases forcing people to download them and to use them and to turn on their Bluetooth, right? These apps are really the tip of the iceberg. It's what we see because it'll show up on our phone's home screen, right? But what they're tapping into are really wells, an iceberg's worth of data from different databases. So in some cases it's location data. In other cases it's full medical histories where data and health records have been digitized. It could be travel data, entry and exit to towns, regions, countries. It could link to your medical insurance or your welfare status, and it could link to other telecom data or other third-party services. And that's where we're really concerned, is that this iceberg, we're going to see the tip, but really not understand the depth of what's below the surface until this is already a required service, and third parties have plenty of access to information that's not actually necessary to fighting this crisis.
Yeah, and what's really interesting about this is that while these industries and these companies are introducing new ways to access and join and align the data, what's really interesting is that all of this data and all of the technology really still exists. It took Apple just yesterday released their iOS, which includes their contact tracing API, which application programming interface. Essentially, it's a set of commands that you can use to build your own app to get this information from Bluetooth data that the phone is already collecting, because you already need to connect to your phone to your headphones, and if it can see other devices, now it's just a matter of storing it. But it seems also like, again, that consent model may not be the best choice if it's going to be this complicated to even understand what data is being collected.
Thanks. So yeah, I can see you're eager to get at that consent model, and I think it's important to note that there are limitations to how effective that can be. First of all, in this scenario, when we're being in a lot of cases rightfully scared pantsless by public health authorities, of course we would consent, right, to all sorts of permissions if it means it's going to save our lives or of our family members or frontline responders. And so, we don't really have the full information to make a really informed choice. Also because we don't know what's below the iceberg of these apps, right? We don't know their full capabilities, and in some cases, the developers probably don't either. I think further, consent models need to be rolled out within a framework where there's the ability to contest norms and to appeal potential violations. And in this country, there is no comprehensive framework to protect our privacy. In the United States, we have a patchwork of laws protecting children's privacy or health data or financial data. We don't have a system to appeal potential violations other than using the FTC or some broad authority like that. So consent is only so good as your ability to hold the powerful actors accountable for potential violations. And what we lack in this country is a system of data protection authorities that is really the de rigueur way of protecting data in the 21st century.
Yeah, and United States law, in terms of picking up on these other things, are just now starting to come around to the idea. California passes the California Consumer Privacy Act in 2000. My goodness, was that 2019? Not that long ago. It's still not in effect. We're still waiting for July 1st. We're still waiting for the regulations that is going to cover some of this under certain circumstances. Right. But United States law is definitely in this place where a lot of those legal protections are not entirely there. And it leads to something else that you had mentioned when we were discussing it earlier, which is sort of this concept of, even if you don't need legal consent, you still need people to buy in. Like at some point, somebody is going to have to download an app, open it up, turn it on, and activate it. And you were pointing to a poll to me earlier that says most Americans are not willing to do that. And so if if we need these things to be effective and we need people to buy in, like, what should consumers be looking for? What should we be looking for? What should we be advising our clients to do to design these in good ways?
Yeah, thanks. I think those are all the right questions. And I think trust really, it is key to public health authorities' ability to leverage health data, because first of all, this isn't going to be the last crisis. This is maybe one of the first public health crises where people do have smartphones by and large. Of course, connectivity and affordability and bandwidth are huge issues in the US that we don't have time to get into. But a lot of people do have smartphones and are producing this data. But there are also key communities who have historical reasons not to trust public health authorities, period. People from communities who've been experimented on, who've traditionally not had equal and fair access to healthcare and health practitioners, right? So there's those communities. There's just this general distrust of tools from Silicon Valley. And again, I think absolutely rightly in a lot of cases, it's probably more the exception that people's data is protected than the rule when it comes to these Silicon Valley platforms that are really hell-bent on profiling, monetization, and the ad-based business model. So throw these things together and it presents a problem. And it's a problem because ultimately, we want the best tools available to keep people safe, right? We in an ideal world would be able to use digital tools to fight this pandemic. But this isn't going to be the first crisis, and that's why it's important on public health authorities, even though they're rushing these apps out immediately, to ensure that they have the ability to be and can be technically reviewed and audited by security specialists and third-party technologists. We have a whole list of do's and don'ts for these apps on my website, and of course they're eluding me now, but we want transparency into how these apps work, what they have access to. The permissions should be fairly clear on their face, and they should be developed with privacy by design, and be able to show the receipts and have an auditable track record and trail, and then keep the data locally. Don't centralize it into a big database. That's been a fight in France and Germany, and that's something that I think Apple and Google got right in there. And I have to correct you. I think they've renamed this exposure notification service rather than contact tracing, right? Because they don't. I think they learned they don't actually want to be able to promise that full contact tracing will happen through this. Even the developers Singapore's much lauded contact tracing service said that it's no alternative. It cannot be the full alternative to real in-person, intensive, expensive, right, manual contact tracing. But yeah. So even with those caveats, there's things that should be built into these apps, it's built on best practice in the space more generally of digital security.
Yeah, and because we got another minute or two on this topic before we move on, I kind of want to pick your brain a little bit about centralization. And you mentioned it very briefly, but the difference between having the data stored on an individual user's phone versus having it go to a central database, because it seems like one of those would be particularly helpful in terms of user control. Like if you have a decentralized model, that data stays on the phone, which means that the user gets to use it and it's not necessarily immediately accessible to everybody else. But it also seems like, and something that I've been struggling with, is that centralized model, if you have the public health authority have immediate access to it, it seems like it'd be more helpful for them in that regard.
Right. We absolutely do promote that the data be stored on the individual's device, because this is the most sensitive data that there is. It's health data, and unfortunately, really, we have too many examples of authorities misusing and abusing access to this data. There are cases we've tracked where sometimes those testing positive have had their identities exposed in public by authorities, and then they're shunned, they're discriminated against, they receive death threats, and there's also examples from South Korea where even though they again are lauded for their response, just outing the fact that individuals who went to gay clubs and went partying a couple weeks ago, who were unfortunately exposed there probably to COVID positive individuals, ended up splashed across the news and turned into a campaign of discrimination and hate against LGBTQ plus individuals and the community broadly. So that's where we see the need to empower individuals, right, with knowledge of how to protect themselves and what their health status is, but really be circumspect about what authorities have access to, what they share with third parties, including private companies, and what they publish.
So we actually have a couple questions, and I think I want to take this. I want to take a step back to answer one of them. We've been asked to explain in general terms how contract tracing would work via an app on the phone, if you can take a stab at it, or I can sort of do a brief explanation and then you can fill in whichever you like.
Yeah, maybe we could tag team. So I mean, I've been informed by Google, I can say specifically, Google and Apple have both reached out to consult digital rights and privacy experts in developing this new exposure notification API, which is best practice, and give us some insights. The way I last heard it, right, which was a couple weeks ago, was for folks who have Bluetooth turned on, Google and Apple found a way for their operating systems, their mobile operating systems, to speak to each other, right? So Android and iOS would be able to share information quietly and quickly. And once they rolled out this API, which they just did, governments and others probably could build apps, put them, if they meet certain safeguards, into the app stores, Google and Apple's. You'll download those apps, turn on your Bluetooth, and then your Bluetooth will collect identifiers of other phones you've been close to over the last 2 weeks. I mean, that's how I heard it was a 14-day period, probably related to that 14-day roughly COVID incubation period, right? So yeah, if you've spent significant time close to another phone that had this enabled, you would share each other's Bluetooth identifiers, collect that list, and then when one of you tests positive, you'll be notified, and then anyone who's on your 2-week list would be notified as well. So how's that, Everett? Is that?
I think that's pretty good. You know, and I will say that, you know, part of what makes answering this question somewhat difficult is that all the players are still in motion. So we don't know exactly how they plan to do it. Bluetooth is convenient because it is standardized, you know, and, you know, Bluetooth standards are Bluetooth standards are Bluetooth standards, but also, you know, in some ways more privacy protective than trying to use cell site location information or GPS, because Bluetooth only is going to give you the information relative to other people. It doesn't actually say this person is on this street at this time. Although I imagine, you know, you could combine that data set, but I don't know if that's a good idea.
Right. Oh yeah, and I'm sure some governments will try. Yeah, and you know, as we're saying, the developer of Bluetooth too was like, this is not a location service. You know, you could spend a lot of time, you know, next to your next door neighbor in the house next door, you know, within 50 feet of them, and your phones would, in theory, you know, connect, but you may not have actual, you know, contact for the purposes of the pandemic's purposes.
Yeah, which I guess goes back to an original point that this has to be one tool in a toolbox. Like, it's not going to replace going to the door and asking questions. It's just going to give, depending on the model, either individuals more information or public health authorities more information to more efficiently target resources.
Absolutely.
We now, another question that we got, I think, actually moves us very nicely into ethical considerations. And, you know, the question is, how do you balance the risk of centralizing data versus conveniency via centrally stored email? So your device is accessing a central server versus having the email messages stored on device and being able to access it in an offline context. You know, and this particular question came from an international traveler. But I think it answers both to, you know, a data security question and then also an attorney ethics question, since this impacts our duties of confidentiality and our duties of competence.
Right. Yeah, and so there's, you know, I'm gonna weasel out as a lawyer, and I guess as a security technologist, and say it depends on your situation, right? We do threat modeling at Access Now's Digital Security Helpline, and different solutions are better for different folks. If you're constantly traveling through places where you are separated from your device, like, you know, highly securitized places like, I don't know, I go to missions to the UN here in New York, and you have to put your phone in a box. You know, if you are separated from your device like that, holding things locally can put you and your contacts at risk. Of course, cloud-based services as well. Cloud's a terrible term. You know, these are heat-producing, you know, not necessarily sustainable servers in nearby rivers or, you know, in real grounded places. But, you know, cloud-based services, you also need to understand their security measures, what they're going to offer you, and ways to connect securely to those. So yeah, threat modeling is key there. I think for this case, you know, Bluetooth is really on your phone, and so that's not going to be something where you're going to be separated from that usually. But yeah, it's a question of what you want to upload, right? Do you want to upload 2 weeks of identifiers of folks that you've been around? Not necessarily.
Yeah, and I mean, that's one of the things about data security that becomes so important, is that, you know, and part of our duty of competence, like we don't all have to suddenly become data security experts. But we do have to understand, you know, what it means when we decide to pull something down and store it on our local device versus, you know, do we leave it on the server where, you know, you might have more systemic protections for it, but it also means it might be accessible in different ways. And I think, you know, and a lot of that has to deal with the duties of confidentiality too. It's like, where are we going to be able to protect those client confidences the best? And in order to do that, we have to understand our infrastructure. And I think, you know, and particularly now, that question just became a lot more complicated because, you know, if you were in a small or medium firm and you had your own office with your own tech setup, we have all of a sudden, that's not the case anymore. You are now almost certainly working from home unless you are one of the, you know, special few that have some very essential businesses that, you know, you have to be on site. And so, you know, when we're thinking about this move from, you know, from our offices where the IT was a bit more managed to here, like, what are the things, like, I think of my local Wi-Fi network as probably my biggest threat vector, but I'm wondering if you have other thoughts on that.
Yeah. I mean, especially if you're in a New York City apartment building and sharing your neighbor's Wi-Fi. Yeah, I think threat environments, you know, so the model has changed since we've started working remotely. A few key steps would be to use a virtual private network, a VPN. Not all VPNs are the same. Not all VPNs are trustworthy. Some you pay for. You can do some research though, like Top 10 VPNs has, you know, ratings. Some that I use, really enjoy using are like TunnelBear with a cute interface, and Siphon is a good one as well. So using VPNs will create a tunnel, right, from your connection to your destination. But that tunnel goes through a mountain, and that mountain is the VPN service itself. And so they can, so you need to know that's trustworthy. So what we're talking about are reasonable steps. And it seems like, yeah, both in California and New York, the duty to protect the confidentiality of client materials and correspondence puts on the attorney the burden to take reasonable steps. And in the digital age, those reasonable steps will involve, you know, understanding the infrastructure, as Everett said, understanding the privacy and security of the services you're using. And encryption is key to VPN's ability to maintain the integrity and the confidentiality of your communications. Encryption is also something that you'll get through specific apps like WhatsApp and Signal, and then there are add-ons to encrypt emails in a really seamless end-to-end way. They're not always easy to use. They're pretty frustrating sometimes, but they often are free. You don't have to pay top dollar, right, or be at a big firm to encrypt your emails or to use a lot of these end-to-end encrypted messaging services. If I could just run through a couple other tools that we recommend. So VPNs, first of all, to encrypt your connection in transit. Encrypting data at rest, right? So data that's held on your computer and your devices is done through full disk encryption, and Apple offers that pretty seamlessly in other services. Don't forget the passphrases, which leads me to password managers, passphrase managers. I like LastPass. It's cloud-based. It can be cloud-based and kind of provide a seamless mobile to desktop solution to keep all of your passphrases in one place, to keep them up to date and keep them strong. So again, VPNs, full disk encryption, passphrase managers. I think the last thing I wanted to mention was protecting your accounts, right? So again, if you are using cloud accounts or social media for your work, you want to make sure that there's more than just a strong password keeping your account secure. So that involves multiple factors. So 2 factors we talk about could be you know, getting an SMS message on your phone, you know, those tokens that you get with your bank account, say when you're logging in there. So most of your accounts should enable you to go into the security or privacy or login settings and click 2-factor or multi-factor authentication on. All right.
And I'm just going to put a plug in here to remind everybody that the technology is important. The human is in many ways more so. Just, you know, quite often, like, social engineering is a huge issue here. And like, all of these protections will not do you any good if you click on the wrong link in that email. You are going, you know, and particularly we have been seeing, you know, there have already been a spate of law firm attacks. And this was before everybody was in their offices and We can't just walk down to our partner's office and say, hey, did you actually want me to order like 3 $500 gift cards and send them off to this address? Because that seems like not a good idea. You know, vigilance over your emails, vigilance over your communications are all still important.
Problem is often between the keyboard and the chair. All right.
Wait, who's there? What? And you know, and so, oh wow, we have some more questions, which I should probably get to. Let's start with this one. You know, we already discussed this a little bit, but a lot of times, and you know, in my class with my students, and a lot of lawyers actually, you know, don't really have a intuitive grasp of the difference between data privacy and data security and those two branches of information governance.
Yeah, that's a great question. I can answer, I think, more at the, using the international frameworks. Well, data privacy, I think we do want to keep it referring to individuals and humans. And data privacy is a human right. It's a fundamental right. It's Article 17 of the International Covenant on Civil and Political Rights. Again, the Charter of Fundamental Rights in the EU has the right to data protection as well as the right to privacy. And so, you know, there's actually, so privacy and data protection, again, we're talking about identifiable individuals. Security, you know, I usually present to my students that security is often more talking about systems, and it's talking about the integrity of the systems and the information they hold. It's about authorized access. So authorized devices, authorized accounts, preventing unauthorized access, again, to systems, devices, and data. And so security, you know, is absolutely necessary, again, to protect individuals in a system, but I do use it in that, usually in that broader sense. If that works, Everett.
I think that works perfectly. Typically, the way I describe data privacy and data protection is it is about the control of information about natural persons. So it's not so much about, you know, how we actually put it in a silo or protect it or anything like that. It's about, you know, who gets to control how it's used and why. And then data security tends to be the siloing of information and how we actually keep all of that done, which is a tool in data privacy and data protection, but it's not exclusive to it.
Right, and just one thing I want to underline from that is that privacy, it's not about secrets and shame, it's about power and control. Privacy is being able to determine, I think, the conditions and the situations where you disclose data, where you disclose information about yourself, your culture, your family, your identity, your business, and controlling the conditions of disclosure, I think is a better frame than, you know, trying to keep everyone out and this kind of isolated person on a desert island sense.
Okay, another question for us. Can you please explain how iOS 13.5 works in context of Face ID when we are wearing masks, and which rights are implicated?
Yeah, unfortunately, yeah, it's a good question. What I know of Face ID is that it does keep data locally, and it does the processing. And all right, so when you engage in a facial recognition system, that system needs to enroll you. So you present yourself. It hashes the image of your face and to a bunch of math, does a bunch of math, and stores that file. And then when it's prompted again, right, on this iOS device, it'll check whether what's in front of it, right, meets that that hashed image inside. And so that's all done again locally, not through some cloud-based centralized database. That's the key thing that I just want to say, and I have no idea what 13.5 may offer that's different. Sorry. Yeah. So when you're wearing masks, right, a lot of these solutions are being tweaked to accommodate mask wearers to identify you by your eyes, your nose. I've heard that earlobes are indicators that are completely identifiable. The gait of your walk, other body parts I won't need to go into right now. I think, they're going to move beyond just the full face scan. But the good thing about iOS is that it keeps it locally.
And we'll take a quick steer into a little bit more, a little bit more philosophy here. Have people compared the securities of data privacy to that of the social contract? Do we need to give up certain privacy for the ability to use such an application? And should we, and how do we measure that?
Right. Again, yeah, that's a question that's very much present in a lot of these machine learning based tools that are being developed. And I'm sure Everett can speak to this. San Francisco did pass with the great work of the NYCLU a ban on certain municipal uses of facial recognition technology. And I think the thinking there was that theoretical benefits are not worth actual existing provable harms, discrimination and abuse, as well as intended uses that end up causing harm. Yes, we answered at the highest level, privacy is not an absolute right. And the human rights framework, your right to an opinion is absolute. You shouldn't be brainwashed. Your right to life, should be protected. But there's going to be trade-offs in any system. I think the point is we want to know what those trade-offs are. And when you develop, again, like these apps are just the tip of the iceberg and then are, required eventually and hooked up to every different system, every different database there is, location data, health data, your passport data, et cetera, the risks grow exponentially, and we can't actually make that determination in a way that's satisfying, I think.
I just want to echo the idea that, all of this is both situational and specific, and particularly in the United States, we go through this sort of, social contract analysis a lot. We just don't do it, we sometimes do it in the courts, but mostly we do it in the legislature. So California passed CAL-ECPA, the California Electronic Communications Privacy Act. I guess that was around 2015, when we, decided that, metadata for electronic communications deserve just as much protection as the contents of messages themselves, which isn't an opinion that we might have had even 20 years ago. Now you have 2 COVID-19 data privacy bills that are sitting in 2 houses of Congress, and we're all sort of, and we're all reacting to very specific things, which is how the United States got some of its laws to begin with. We have SEC regulations about certain types of financial data. We have, health data has its own set of laws. It has HIPAA. And I would say that, in terms of the broader social contract, we're constantly having this discussion. It is what makes information privacy and data protection law so interesting, is that it's very dynamic, even when it's kind of a calmer time.
Absolutely, yeah. This is a great area of law to go into. I think as a young lawyer, law student, data is not going away. Data absolutely fuels the economy. I'm not going to call it oil, but it does fuel, a lot of different social systems and economic systems, and that's not going to go away. So it's an important area to get into, and yeah, I mean, I really have to say, I think just from an efficiency standpoint, the European approach, where you say, period, if data is identifiable to an individual, a natural person, as Everett put it, that data needs to be protected. And this is, I think, from a business standpoint, a much more efficient way to approach this and to carve up the pie in so many different ways with HIPAA and COPPA and these new data. And I heard they're actually calling them data protection bills now. They were called data privacy, but I think even Congress has wholesale adopted that terminology from the EU of data protection.
But CCPA still calls it personal information. So we're going to have some terminology problems for the foreseeable future. Actually, this is a perfect transition to another question. And I know that, Peter, you wanted to talk about this too, and I think it's near and dear to our hearts anyway. There is somebody coming to USF in the fall, either, and would like to hear our advice on what to focus on if you want to pursue a career in data privacy.
Cool. Yeah, well, I just want to take this opportunity to shout out my awesome professors. I really had a good experience at USF, including in the burgeoning area of privacy. So I studied with Julie Nice, the poverty law professor then, and looked at the privacy rights of public assistance recipients, of welfare recipients in California, and wrote a law review article on that. Also, of course, Susan Freewald, now the Dean Freewald's work on cyber law, which I think Everett has taken up. You want to look into. I also took, international comparative law, which gave me understanding of the civil law framework. The code-based systems are popular in the EU, and that's important because this is really reverberating globally, that this EU approach with the General Data Protection Regulation. So those are three, and I don't want to think, oh yeah, and then Connie de la Vega's course, of course, I have to, I got a shout out to the Human Rights Clinic, which actually brought me to Geneva for the first time, and over the last 8 years, I've been able to continue to engage at the UN, including on the new privacy resolution that started after the Snowden disclosures, and cybersecurity work at the UN. So there's a few professors, but the Bay Area is a fantastic place to study this stuff, as Everett and their law firm knows. The Electronic Frontier Foundation is just down the street from USF Law, and my old mentor David Green is there at EFF. So great resources.
So I now have to echo the plug for EFF because I'm also an EFF alum.
Great.
And I do want to put an emphasis a little bit on international comparative law. Just even before you understand data privacy and data protection and how Europe approaches it, one of the things that you have to understand is how Europe, aside from the United Kingdom and Ireland, approaches law. And it's a very different beast when you're trying to learn it for the first time. I definitely have to put in a plug in for that. I also have to put in a plug for my class because I teach information privacy law. And we actually now have a privacy law association. So there is now a PLSA, which, it's just a lot of people that are very interested in the subject matter. I think more importantly, than that is just a lot of intellectual curiosity and a little bit of willing to learn technical jargon. It is not as intricate as people think it is.
Right. Yeah, plus one. I think you can come at privacy, again, from a lot of different ways, and we need people to come from different fields and different backgrounds to make this meaningful, because, from the tech understanding, I think you can learn. I've learned enough, I think, because people, technologists are often really, curious about law. Well, they think all the problems that they can't solve are solvable through law, and we think all the problems are solvable through tech. But there can be a good interchange there. But yeah, I just want to emphasize that we need people that understand, communities, understand social justice, understand especially economic inequality, to take an interest in privacy law.
Yeah, there are so many different approaches to this, and there are so many ways to get into it. In some ways, part of, and in many ways, part of privacy is now moving into, it's moving into all these fields too. So privacy is becoming part of corporate compliance. Privacy is becoming part of public defenders and criminal defense law. Privacy is becoming part of international commerce and business law. And the number of times that I have had to look at a contract, not for the service, but just to transfer data from one place to another place, that has made up 80-90% of my days on certain days. So
yeah, even intra-company transfers, if you have an office in Brussels as we do, and want to transfer personnel data or something, it's, there's clauses, and yeah, it's a huge field.
I just wanted to interject really quickly. This is really fantastic material, and thank you so much to both of you for being available. I just wanted to give a 5-minute check, so we'll be done right at noon. But thank you so much, both of you, and I'll let you share your closing thoughts.
Peter, after you.
Great. So yeah, thanks again. I think we've emphasized that this is a new and growing area of law. It has a deep history in constitutional law and international frameworks, but it's absolutely of the moment, and we need more eyes on this, especially people who get the kind of rounded social justice-based education that USF Law provides. Privacy is about power and control, and we do need to create a world where the information and the knowledge is not just controlled by either few governments or few companies. And we need to empower individuals to be able to understand enough to protect themselves when we go online. And these days, this mass digitalization, as the UN Secretary General has put it, has taken hold and doesn't look likely to turn around. So we are living our lives online, and we need to exercise our rights online. And privacy is really central to that. I think there are practical ways you can get involved, even if you don't work directly on tech or on privacy. You might have a compliance practice. Your firm might need to look at confidentiality obligations, at contracts with cloud service vendors, and employment rules. And these are all places where, it will behoove you to understand a bit about the tech, what to look out for in terms of safeguards, who's holding the data, how's that data encrypted, and under who has access to that data, under what permissions. And these are the basic questions that I think you should ask yourself as a lawyer operating in the digital age. And hopefully organizations like Access Now, like Electronic Frontier Foundation, private firms like Swilgen, will provide enough resources that your professors can direct you to, and your alumni can offer. So thanks again, and really happy to be part of this, and hope you all stay safe online and off.
And I think that is a perfect place for us to leave it. Peter, thank you for doing this with me. Caroline, thank you for hosting us. I'm going to turn it back over to you.
Perfect. Well, thank you so much to both of you, Peter and Everett. You were handpicked by Dean Susan Freewald. She is very proud of both of you, and this is just a very timely and important topic for us to be covering right now. And thank you for being available and for this wonderful information. Thanks to each of our attendees as well. Just as a reminder, this was recorded, so we'll be emailing it to you shortly. Thanks so much, everyone, and be well and safe.
Thanks, Caroline. Bye.